Brendan Dassey trial transcript, day 6, continuing on page 56, re-cross-examination by attorney Edelstein. So if Stephen Avery had told Brendan Dassey, when Brendan got over there, I shot Teresa in the garage, you need to help me clean it up. That's certainly a possibility, isn't it? Are you saying that's all he told him? No, I'm just asking you. You said that in order to scientifically connect the defendant, you pointed to the bullet fragment with Teresa's DNA, right? That is correct, yes. I'm not going to argue with you. We know it has her DNA, yes, right? And that came from the gun, right? Yes. You don't know how many times he was in that garage before the 31st, do you? How many times Brendan was in the garage? Right. No, I don't. You don't know how many times he sat around watching Steve burn things in that pit, do you? No. You don't know if he ever saw that rake and shovel that's been paraded around up here before the 31st, do you? No, he said he got them out of the garage. So he could have had pre-existing knowledge of the rake and the shovel, right? Sure, he could have. He could have had pre-existing knowledge about that gun hanging up there in that bedroom, couldn't he? I'm assuming he could have. All right, this all occurred October 31, right? Yes. And he said that he told you that he helped Steve clean up this mess, right? In the garage? He said he helped do a lot of things. One of the things was help, listen, clean up the garage, yes. Okay, and he talked about using bleach, right? Yes. So the fact that there's a bleach bottle that is discovered some 4 months later in Steve's trailer, you're telling this jury is scientific evidence to corroborate what he said? I'm telling you to put it all together along with the gas cap. Let them put it together. Absolutely. Do you just answer my question? Yes, I am. That bleach bottle wasn't scientifically analyzed to determine whether it had Brendan's DNA on it, was it? No. It wasn't scientifically analyzed to determine whether it had his fingerprints on it, was it? Wouldn't expect it to. You don't know how long that thing had been sitting there, do you? I don't. You told Mr. Fallon you had a pretty fair command of the forensic evidence by the time you conducted the interview, right? I knew the majority of it. All right. When did you, well, let me ask you this way. Did I understand you to say that it was February 27 was the first time that you had any knowledge about a gunshot wound being an issue in this case? I can tell you that there was a report written by somebody at the crime lab on the 27th about a suspected gunshot wound, and we received it on the 28th. There may have been conversations with, for example, Leslie Eisenberg, who you saw testify about the skull pieces earlier than that. I didn't, excuse me, what was that about earlier than the 27th from Eisenberg? I said there may have been discussions that she may have found one piece of skull earlier than that. Let me ask you this, but I don't know. Well, do you have a recollection of being told as early as November 15 of 05 from your lead co-investigator, Agent Fossbender, that he got information from Eisenberg that there was clear evidence of a gunshot wound? Do I have an independent recollection of that? No, but I believe that would be true that, all right. I don't know that she could say it was a clear wound at that time. She had a suspect that there was one at that time. Yeah, that's probably true. All right, so it certainly wasn't a revelation from Brendan that there was an issue of a gunshot wound, correct? One gunshot wound. You already knew this going into this interview? One gunshot wound, yes, I said that, yes. You also indicated in response to counsel's question about corroborating what he said to you from a scientific standpoint that he told you Stephen had a cut finger and you found some blood, right? True. If he was over there tending the fire and he saw Steve had a cut finger, does that surprise you? He even said Steve went in and got a Band-Aid to put on it when he was... So what, if he sees a cut finger and he says he got a Band-Aid, how is that scientific? It's knowledge that he would have known, and it's not, puts him there. Okay, that's all. The court, all right, you may step down. The witness, thank you, Your Honor. The court, any exhibits? Attorney Edelstein, Your Honor, we haven't moved that exhibit that the witness has. The court, the transcript 216, I think? Attorney Edelstein, right, yes, 216. The court, all right. Attorney Fallon, no objection to that. The court, all right, that's received. Attorney Freeman, I think with the same conditions we've talked about. Attorney Edelstein, right, for purposes of the record. The court, right. Any further witness? I'm sorry. The clerk, 215 hasn't been received yet. The court. And 215 is? The clerk, report and transcript of the 227 interview. Attorney Edelstein, same motion for the same purpose. Attorney Fallon, that one I may want to think about, but let me just begin by saying for the purposes of which it was specifically identified and the specific questions referenced, I have no objection, but for any other purposes, so in other words, for those limited purposes, I have no objection. The court, all right, it's received. Attorney Edelstein, all right. The court, for those limited, Attorney Edelstein, and I'm going to the court, purposes. Attorney Edelstein, Your Honor, just so that we have cleanup, I think number 214, which was the court, Miranda rights form, the clerk, that was received. The court, that was received. Attorney Edelstein, very good, thank you. The court, all right. Attorney Fallon, Madam Clerk, are there any other exhibits unaccounted for at this time that we need to address? The clerk, no. The court, well, any further witnesses from the state? Attorney Fallon, the state at this time would offer to the court no further witnesses. We would rest our case and reserve our right to rebut, argue, or rather evidence presented by the defense. The court, all right. Is the defense prepared to proceed? Attorney Freeman, Judge, we do have issues to deal with prior to proceeding. The court, all right. We'll deal with those issues. I'll excuse the jury. Attorney Fallon, pretty close to the morning break time anyways. The court, it is. Jury out at 9:58 a.m. The court, all right. Be seated. You have a motion, Mr. Freeman? Attorney Freeman, Judge, yes. Before we start our portion of the trial, we would move, and I believe it's count 2, the sexual assault offense. We would move that the court consider at this time dismissal of that count. The evidence thus far that's been introduced this past week, in our opinion, does not independently support the first-degree sexual assault charge as to any element of that offense, absent the confession of the defendant. Now, it supports, general rule is that one may not be convicted solely upon their uncorroborated confession, but I can cite cases. Triplet v. State is the one that I have, 65 Wis 2D 371. I believe Holt v. State is 17 Wis 2D 468. More of the primary case in Wisconsin in regards to corroborated confessions. But in that regard, I believe it was in State v. Verhasselt, 83 Wis 2D 647, Wisconsin Supreme Court case. Supreme Court stated that, quote, as to the need for corroborating evidence, all of the elements of the crime do not have to be proved independently of an accused's confession. Essentially, it's enough that, quote, some corroboration, unquote, of that confession be necessary in order to sustain a conviction. That's the Supreme Court in Verhasselt. In this case, there are 3 crimes. There are 3 distinct and separate offenses. Each has distinct and separate elements of the offenses. Now, certainly we, not taking issue that there has been independent evidence that supports at least an element of the other 2 offenses, first-degree intentional homicide and mutilation of a corpse. In this case, there's been no independent evidence to support the confession by the defendant that first-degree sexual assault occurred. There's no independent evidence outside the statement, the videotape statement provided yesterday to the court. No scientific evidence that ties the defendant to any sexual assault. No physical evidence that even suggests that a sexual assault occurred. Nothing connects this defendant with Teresa Halbach in regards to any indication of a sex crime. For example, no DNA of Teresa Halbach on the leg irons or handcuffs, items that might be indicative of a sex crime. No indication of bodily fluids indicative of a sex crime, such as semen. Nothing on any bedding or on any carpeting. No body fluids at all suggestive of a sexual assault. So we'd ask that the court dismiss that count in regards to the uncorroborated detail of any element of that crime. The court. Response? Attorney Kratz. Thank you, Judge. This motion is brought, not surprisingly, at the conclusion of the state's case, where the standard the court is to apply is whether a view of the evidence in the light most favorable to the state could sustain a conviction. Mr. Freeman's argument, I believe, is misplaced, especially given the post-mortem mutilation of the evidence and the destruction of what we might expect to find as other corroborative physical evidence. In this case, the fact that the body is totally consumed by fire, the fact that the bedding and the clothes, which may have at one point contained DNA, are by the defendant's own instrumentality burned, do not aver to the benefit of the defendant himself. The term corroboration, Your Honor, requires or suggests this court include and consider all of the evidence that has been presented. There is certainly corroboration as to restraints, as to weaponry, and as to other items that have been seized when viewed in light most favorable to the state would in fact be considered or can be considered corroborative. But the bottom line and the underlying principle is when viewed in light most favorable to the state, whether or not the jury could in fact convict, we certainly have met that burden. We ask that the defendant's motion be dismissed, or excuse me, denied at this time. The court response. Attorney Freeman, just one quick response, Judge. The case that I cited, and I think it's cited numerous times and without, well, somewhat ad nauseum in the case law, says the elements of the crime, not any element of the crime. I'm sorry, not any element of any crime. I think if the Supreme Court wanted to say any element of any crime charge, they would have done that. So in this case, there isn't any evidence suggestive of any sexual assault. And despite the fact that there might be evidence that the state suggests had been destroyed, once again, that comes from the confession of the defendant. There's nothing to corroborate that there was bedding in the fire. No evidence has been suggested that they found remnants of bedding in the fire. So once again, I understand the state's position, but the case law is pretty clear. There has to be something other than the confession. Not just, well, it's not fair that he can confess to something, destroy all of the evidence, and then we can't go any further with the case because we can't corroborate the confession. That's the law. The court. I think, and I don't have any cases in front of me right now, but most recently there was a case called State v. Bannister. It's at 2006 Wisconsin Appellate, something or other, and that stated, once again, what I think essentially both defense and prosecution agree, that an uncorroborated confession cannot stand alone to sustain a conviction. What I believe the general rule is that there has to be some material fact that corroborates in one way or another the confession. The state is correct in saying that at this stage in the proceeding, there need be shown here a prima facie case to allow the court to conclude, under the best of all circumstances, at least as viewed from the prosecution standpoint, that a case has been entered that could convict a defendant on a particular charge. In this particular instance, the state finds some of the implements described in the statement of this defendant and introduced by way of the videotape and the implements themselves, introduced here as pieces of evidence to be sufficient material corroborating evidence to at least move this beyond this stage in the proceedings, and I'll respectfully deny your motion. Attorney Kratz, when would you like us back, Judge? The court, 10:25. Recess had at 10:27 a.m., reconvened at 10:20, I'm sorry, recess had at 10:07 a.m., reconvened at 10:27 a.m. The court, Mr. Freeman? Attorney Freeman, thank you, Judge. We'd call first Chris Schonenberger-Gross.